May I be permitted to mention one criminal division motion statute? My lords.
Motion.
Criminal division.
My lord, may I be
Sir,
permitted to
yes,
mention the matter? CO 75/2025 for the purpose of extension of interim order. It's a civil revisional application.
Lordship,
Grateful, Your Honor.
extension of interim order, Lordship.
Civil or criminal?
My lord, may be permitted to mention for correction only. Because after question, my lord, has passed an order, whether full case number, in the order sheet is Rani gone instead of Rai. Correction. Yes, my lord.
Hey, it to be mentioned in here. What happened?
Lordship, if I may be.
In একটা correction আছে এটা কালকে নিয়ে আসুন to be mentioned. Yes,
Lordship, for upgradation, Lordship, this is in today's, this being item number 14.
upgrades are not possible. Don't request.
Lordship, if I may be permitted to mention a criminal revisional application for extension of interim order, Lordship.
Call the list.
May I permitted to mention, Lordship, it is a civil divisional matter for inclusion in the legislation.
Hearing.
A new motion, civil motion. Yes, motion.
Item number 1.
Yeah, so notice of it is different. The instant matter is listed today under the
The content application. I was passed an order on 8.25. The land acquisition is filed. To disburse the compensation amount. Within 4 days.
they have not preferred any appeal.
No. Communicated them the order like. Is the affidavit of service.
আসুন আসুন decision Prior to service,
This contempt application I have served on them. And this letter of communication also was served, my lord. Thereafter, they have even written me a letter, my lord, which is in page number 60. The amount of compensation will be paid to the petitioner after the process of rectification of our list is done. That's in page number 16, ma'am. I have
the
communicated.
affidavit of service as filed today on behalf of the alleged, on behalf of
Transfer application. On the last submission, the opposite party take time to file given an obligation.
who is for the opposite party.
Transfer who appeared. To the appealing party.
Where is he? It is under old act or new act?
Old act.
At that time, CRPC was in vogue. একটু CRPC টা তিনটে একটু বার করুন। এক মিনিট। What difficulty you are facing? It is a DV Act case.
The opposite party being the complaint and file a case against the petitioners. under
You are the angry person.
And the 80% and the mother-in-law, father-in-law and the.
Oh, you are the opposite party there.
Plus. At the time of appearing before the learned court, I was threatened and I was assaulted by the Kunz appointed by the
You are a resident of which place?
Kunz.
Oh no, you want to put trouble to the lady.
Lordship, I clear the old aged persons as well as the sufferer.
Which paragraph is relevant?
Paragraph 7,
Place,
8%.
place.
Eighteenth of 2023, the petitioner number 1 and 2 and 3 went to Malda court for appearance of this case. Surprisingly, the opposite party complained near Shanti Mandir along with the other accused persons to attack both the petitioner number 1 and 3 while returning at court. As a result of which they sustained severe bodily injuries and stole the gold chain of the petitioner number 3 and threatened more dire consequences if they visit Malda court premises. Some of the managed to rescue themselves and the petitioner number 1 had been required to admit in the hospital and Mr. Discharge certificate of the petitioner number 1 is carrying mentioned appearance of the blunt injury in the backside of his head. Upper head. That is annexure number 3, Lordship. Page number 26.
Age 26.
The mother-in-law of the complaint who was being assaulted by the tools of the actually the complaint has been lodged against the complainant by the petitioner. That's page number 27. The petitioners are restricted to enter in the court premises. And page number 24 also is there. Which is not verification number 6. Because the superintendent of school.
Where is your injury report? There is a discharge certificate.
Learned from a back of mentioned in the
Care of physical assault by whom?
by the people who must be who's appointed by the complaint. As a matter was instituted by the percentage, the sharp part will be, will be done essentially with the by the honorable, very order, by the order of the honorable.
Who's your other side? Why is not appearing?
Opposite party appeared at the last one.
Fortunate state of affairs. You're enjoying stay.
Actually, this stay has been vacated. The last year is 23rd of October to 2025.
Then you have to file a fresh application.
That's the order.
23rd?
23rd of October. September.
September of which year?
2025 is the next date.
The petitioners are represented today. None appears on behalf of the opposite party number 2. Though
I'm for the state order.
Model was granted on 18th of June 2025. It was still 12th of August. And this application was filed on 29th of July before expiry of the equity order.
CD is here.
Yes, Miller. Sufficient material is there, Miller. That is submitted, Miller. 41A has not been formed. On 61 of eyewitness is there, Miller. This is a case and counter case, Miller.
The actual fact is not in certain worship.
Injury is there, though the nature of injury is simple, but injury is there. একটু দিন।
Charge sheet was submitted under which section, sir?
Charge sheet submit.
Last paragraph.
My lord, charge sheet submitted 341, 323, 379, 506, 34 IPC.
May I for
161 on several eyewitnesses there.
May I say for
Prima facie material is there, my lord, for trial.
I was declared for the extension of interim order to the Lordship.
Why?
Kindly take up tomorrow.
Why extension, my lord?
Because Lordship.
They have enjoyed enough extension.
No, no, everybody.
You are not ready, but the court is ready.
Kindly take it up tomorrow.
No, sir.
The heaven will not fall, Lordship. Kindly take it up.
Heaven will fall, sir.
No. Kindly take it.
No, why? Sorry.
Kindly tomorrow. I did not bring them.
There are sufficient materials.
No, Lordship, I have some ground, Lordship. Kindly take it up tomorrow.
Not only that, my lord, but 41A has not been covered. Why?
Kindly.
The presumption will come that he is guilty.
Kindly tomorrow, Lordship. Kindly.
As per request made on behalf of the petition, let the matter be listed tomorrow under the same heading. CD be detained
Tomorrow,
tomorrow. Date দিয়ে দেবেন.
I'm grateful to those.
In my court, extension is not a matter of court, sir. So be rest assured and convey this message to your brothers and sisters. Let the matter be placed before the next available circuit bench under the same heading. Let the matter be placed before the next available circuit bench under the same heading. Same order. Oh.
Item number 7, this revisional application, my lord, I have challenged, my lord, the CR case number, my lord, 623 of 2024, a complaint case. My lord, that has been instituted by the, my lord, the opposite party wife. There is, my lord, the opposite party number 2. My lord, the CR case, my lord, and its subsequent orders. My lord, the certified copy, my lord, can be. That is upload page below 22. My lord, the opposite party wife has, my lord, filed this complaint case, my lord, assailing, my lord, all the in-laws. But I happens to be, my lord, the opposite party number, accused person number 4 and 5.
Give me a second.
Lost.
Yes, ma'am, sir.
What is my status, which measures petitioner status?
Who is he?
This petitioner, petitioner number 1 is one of the sister-in-law, and petitioner number 2 is her husband.
My lord, the fact remains that, my lord, we are the, my lord, the permanent resident of Calcutta. We are the permanent resident of Calcutta. So far, my lord, the averments of the complaint case is concerned, my lord, some, my lord, frivolous and omnibus, my lord, allegation has been.
আসুন 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 at the time of hearing, Mr. Miss
No, I am for the petition. Or in the present revisional application, the petition is challenging the order of 127 of the CRPC. Initially in the year of 2014, my lord, the opposite party number 2 filed an application under section 125 of CRPC, my lord, where 6,000 was allowed on behalf of for the wife and 4,000 was allowed for the minor girl, my lord. Thereafter,
How much was allowed, sir?
my lord, 6,000 for the 125 application, 6,000 for the wife and 4,000 for the minor girl.
Wife, 6,000.
In the year of 2014.
Daughter,
Daughter had a 4,000. 10,000 was allowed for him.
4,000. In the year?
2014. Thereafter, madam, in the year of 2024, he filed an application. She filed an application under section 127.
For enhancement.
For enhancement. Where my
Yeah, 127 filed on
2024 and my lord order dated my lords 12 of February 2020.
very good. 12th February order has been enclosed.
Yes.
Certified copy is there.
Yes, page 29 and 30, my lord. Relevant portion 29 and 30. 29 last portion.
So now it has been enhanced.
It has been enhanced, my lord. But my lord, it was hard ex parte, and my lord enhanced for the wife 6,000 enhanced to 10.
So why you have chosen not to appear, which is why it was expired.
My lord, I did not get a copy. That is the.
How can it be? How can it be, sir?
Let me know. May I know?
Please.
My lord, in the 127 application, 6,000 enhanced to 10,000 and my lord 4,000 enhanced to 8,000. Total 18,000 and my lord 5,000 was for the litigation cost. Now the my lord case of the petitioner is that if your lordship kindly comes to page number 13, my lord.
I am there only.
Page slip of the where, my lord. If your lordship kindly see, my lord,
You
43,000.
are complying with the order of the 125.
Fine. Till 2014. From 2014.
Where is your affirmation to that effect in the pleading? That you are regularly paying?
My lord, page 4, paragraph 4. The petition humbly submits the opposite party number 1 voluntarily left the house. Petitioner going to make payment per month in order under additional substitution.
Petitioner is going to make payment per month as per our. Yes,
Well,
then what happened? Page number 13, you are there.
My lord.
How much is your salary?
My lord, 43,000 net pay, my lord.
No, your gross salary is 62,000.
My lord, after deduction, I only get 43.
Let me deduction, PF contribution 3,700.
Everything.
Professional tax, festival advance, PF loan, that will not be deducted.
My lord, that is my lord.
43,000, 62,000. Professional tax. PF. Death relief fund, CBBWA. So very paltry amount, say 300,
My lord,
say 500.
my lord, 43,000 I got in my hand.
43,000, that is after deduction of your PF contribution, and you have taken also PF loan.
My lord, that is as because my lord, if your lordship kindly comes to the page number 14, my lord, next page, my lord.
Huh.
My lord, the medical documents of the mother of the petitioner, my lord, who is 95 years old. It is in the year of 2013, 2023. If your
On
lordship-
that ground, you cannot escape, sir.
If your page
If
number
you have a
7
duty with your to your mother, you have a duty to your wife and daughter.
I also paid, my lord. That is why I paid till from 2014, my lord. My lord, I have a 95 years.
So why you have chosen not to appear before the trial court?
My lord, so far instruction, my lord, he did not.
What is the averment? You are a desperate person.
My lord, I made the payment
Ah.
2014, my lord, without. my
No,
lord,
no averment as
without
why you have chosen.
Without any unblemished record. Kindly see, my lord.
Can it be
My lord, I
considered?
am for 55.
Sir, can it be considered as a charity?
My lord,
If I'm paying my wife, if I'm paying my wife and daughter, can it be a charity? It is your duty, sir.
okay, but my lord, kindly see my condition also, my lord. I have a 43,000.
I look after my parents.
My lord, I have a 95-year-old mother, my lord.
I look after, for the sake of, I look after my parents. Can it be said as it is a credit? It is a duty, it is our duty,
My
sir.
lord, but
It is our solemn duty.
my lord,
Then,
my lord, kindly look into my
এই এসিটা
condition.
একটু বন্ধ করো।
I have a 43,000 net pay in my hand. My lord, I have a 95-year-old ailing mothers, my lord. If your lordship, my lord, kindly see the 95 years old and how much I have to pay before my to maintain my mother.
Take
And
down the
thereafter, my
subject
lord,
matter of the instant revisional application.
I
Judicial application, my lord, they have come against the order of the judicial magistrate Jalpaiguri issued warrant of arrest against the petition.
In a proceeding,
My lord, in a proceeding, my lord, under section 376, 511 of the Indian Penal Code, FIR, I have very vague allegations.
hmm,
From the FIR, asserted that she is a consenting lady. However, my lord, the petitioner arrested on 12th of February 2018, and subsequently, my lord, the order of bail has been granted on 26th of March 2018. Now, my lord, I am very candidly submit before your lordship. My lord, after obtaining the order of bail, petitioner did not appear before the learned trial court. As the my lord, the petitioner was under impression that after obtaining the bail, my lord, there is no need to appear.
let him remain on impression.
My lord, the petitioner was not being communicated.
Ah.
The advocate also, my lord, I have stated everything, lordship, in paragraph number 6 and 7. My lord, the.
When the bail was granted.
Yes, lord. Certified copy, bail, lordship kindly comes to the order dated 26/3/2018. It's not so legible, lordship has got it.
26/3.
Yes, your lordship. My lord, I have stated in paragraph number 6 and 7 of my petition. My lord, he was out of station for his livelihood. In the meantime, COVID started. My lord, he wants to surrender, lordship, kindly give me some protection so that he can surrender, lordship.
In the court of learned CGM, Jalpaiguri COVID is still on. Oh, I was under impression that in the court of CGM, the COVID virus is still active.
I have stated my petition, lordship, paragraph number 6 and 7. Lordship, kindly see.
Madam, all along Bappa was found to be absent without any step.
That is fine, my candidate submit, he never appeared.
But the difficulty, your candidate submission does not persuade the court.
Kindly consider, lordship, you want to surrender.
Your candidate submission does not persuade the court. That is the whole difficulty, madam. What can be done? If it is undone, how can it be done? I cannot understand.
Lordship, kindly consider that if he appeared to the officials, that means that he had knowledge that he had to appear. But he never appeared, my lord, he was completely unaware of this proceeding, lordship. Otherwise, lordship, this would not have been happened, lordship.
He is a resident of which place?
My lord, he is a resident of lordship.
Siliguri or Jalpaiguri?
Jalpaiguri.
No, under the Siliguri Municipal Corporation.
Yes, yes.
And the court is which court passed the order?
My lord, it is judicial magistrate Jalpaiguri, lordship.
Asun. Learned advocate for the revisionist request this court to place the matter before the next available circuit bench. Such prayer is constantly allowed. Let the matter be listed before the next available circuit bench under the same heading.
Led by Mr. Akash Bhushan.
Same prayer.
No one. He's appearing absolutely.
My lord, I am appearing on behalf of the petitioner, my lord. Item number 11. My lord, am I audible?
You are audible, visible, but give me a second, sir. Yes,
My lord, in this matter,
it
I am
is
being led
available. Very good. Let me see. Yes.
My lord, in this matter, I am being led by Mr. Saurabh Chatterjee, senior advocate. My lord, in this matter, there are prior 5 FIRs. In 4 FIRs, we have been granted stay. In the 5th FIR has been merged with the 4th FIR.
Four is already in stay. One is clubbed with the another application and one is remaining. Total 6 FIR is there. As per my knowledge. Wait. Wait, Mr. Chakraborty. Yes, sir.
My lord, these 5 FIRs, in total 5 FIRs is pending adjudication before the Honorable Justice Dr. Ajay Kumar Mukherjee. My lord, under such circumstances, since the parties are same, the allegations are same, the contentions are same, my lord, if my lord deems it fit to transfer this case, my lord.
Transfer I cannot do. It is not within the domain of my. It is not within my domain. It
My
is
lord, in just in order to avoid
to
conflicting
approach
orders,
the Honorable the Chief Justice for assignment then. If all connected matters are pending for a coordinate bench, you have to approach the Honorable the Chief Justice for assignment before that bench. That power I don't have, sir.
my lord may not be able to release this case.
But the other matter is part matter, so just all, no, then he has to have take appropriate steps for assignment, no? Then what do you do, sir?
My lord, if my lord may not be able to release this case from my lordship's court, my lord, then kindly, then I am seeking a day's adjournment, my lord, since Mr. Chatterjee will be appearing in this matter, my lord.
Should I record that you will make a prayer for assignment? Or you will take instruction from your senior?
My lord, I'm intending to take
Very
legal
good.
steps.
He will be he's led by Mr. Chatterjee, otherwise he will be difficult. On behalf of the petitioner and Acha. Learned advocate for the petitioner is hereby requested to cause service of notice upon the opposite parties along with a copy of the instant application for quashing and to file affidavit of service on the adjourned date. মাত্র কিছু করার নেই। Next circuit তো করে নিচ্ছি।
Grateful, my lord.
Yes, Lord.
Right to, my lord, appoint, my lord, a counsel according to an accused choice. My lord, is a constitutional as well as statutory right under Article 22 and 303 of the Criminal Procedure Code. My lord, in this matter, my lord, these particular petitioners, my lord, three petitioners, they have been, my lord, arraigned in a criminal case. My lord, the case was started under several penal provision, including 307. My lord, the 302 as well as 307. My lord, the trial was, my lord, initiated. My lord, all of a sudden, my lord, kindly come to page 26. That is the order dated 27th of November 2024. My lord, what happened, my lord? The learned counsel, my lord, who was representing, my lord, these accused petitioners. My lord, my lord, retired from my lord, his brief. And my lord, on that effect, my lord, an order was passed. My lord, the learned trial court was pleased to appoint, my lord, and counsel from my lord, the legal service authority.
Give me a second, sir.
Lordship, on page 26.
So Mr. Shukanto Aich retired from the brief.
Retired from
From the
his, my
case.
lord, brief.
Huh.
My lord, that is, but kindly come to paragraph 9 of the order dated 27th of November 2024. Paragraph 9. My lord, Secretary DLSA Alipurduar is requested to appoint an advocate from the existing panel to represent all the above mentioned three accused persons as soon as possible. Let a copy of this order be forwarded to the Secretary DLSA Alipurduar for doing the needful. My lord, the learned court was pleased to, my lord, direct the DLSA, my lord, to appoint an advocate. My lord, on that very day, my lord, that is on 27th of my lord, November 2024. My lord, after that, my lord, a tight schedule, my lord, was, my lord, framed by the learned trial court, my lord, to commence the trial. And
Because there was a direction from the honorable court.
because there was the direction that no adjournment should be granted. My lord, on 28th of 11, 2024, my lord, the schedule has been framed. My lord, that is the next order, page 27. And thereafter, relentlessly, my lord, the trial was commenced. By appointing, my lord,
Have you expressed your desire?
Yes, my
that
lord.
you
My lord,
intend
kindly-
to appoint your own advocate?
My lord, kindly come to, my lord, the order impugned, order dated, my lord, 8th of May 2025. That is the last
8th of May.
8th of May, my lord. That is after page 67. After page 67.
No. When Mr. Aich retires,
Lordship.
that is on 27/11/2024.
Yes.
And on 28/11/2024, when cross-examination of PW1
My lord,
was completed, at that time, have you made any petition?
No, my lord, opportunity was given to the petitioner accused person, my lord, to appoint a counsel, my lord, according to their choice. My lord, I have filed, what I have done, my lord, I have filed a petition, my lord, under section 311 of the CRPC for recalling of the, my lord, the evidences. My lord, kindly come to, my lord, page 30.
Yes.
My lord, I have filed a petition under section 311. My lord, order dated 17th of January 2025. That was filed, that was kept in record, but that was no opportunity was given, my lord, for hearing of this petition.
311 deals with?
My lord, for re-examination of the evidence, my lord.
No, I want to know where is your desire to appoint your another lawyer?
My lord, I have not given a single opportunity, my lord, to express my wish, my lord. As because, my lord, the trial was framed, my lord, in a very tight schedule.
But
Relentlessly, my lord, the
it
trial
does
was
not-
commenced.
Naturally, it should have been.
Lordship,
It's a sessions trial. It should be done in manner.
my lord,
So what wrong has been committed?
my lord, there was a direction, my lord, to
It is not so innocent as you are pleading, sir. It may be a dilatory tactics.
my lord, kindly come to, my lord, the last impugned order. The last impugned order. My lord, only, my lord, my grievance is that, my lord, I have the application filed under section 311, my lord, has not been considered. The last impugned order, that is, my lord, on 8th of May 2025. My lord, as because, my lord, I could not, my lord, reach the court, my lord, within time, this application has also been turned down. That is the impugned order.
So
dated
you,
8th of May.
at that material time, you were represented by your appointed
I
lawyer.
was given a new vakalatnama, I filed, and thereafter, my lord, this application under section 311 has been filed for recalling the, my lord, witnesses. So, my lord, I have not been given, my lord, the precise opportunity, my lord, to defend myself.
Learned defense counsel Satyajit Pal is found absent.
Lordship,
So make a complaint against Mr. Pal before the Bar Council of West Bengal. It would be easier.
my lord, my only grievance is that, my lord, let this, my lord, application under section 311, my lord, be reconsidered, so that, my lord, re-examination could effected. Re-examination could be done. Because otherwise, my lord, I would be left for, my lord, without defense. The vital, my lord, witnesses has not.
You yourself are foregoing your defense only to protract the trial. That
No,
is the main
No, ma'am.
main reason
No,
for
ma'am.
filing.
No.
All these tactics are known to
But
us.
I beg of your pardon, your lordship, my lord. On, my lord, the last date, my lord, when, my lord, the learned counsel retired from his brief, my lord, my lord, the learned trial court was in hurry, my lord, to appoint the counsel from the, my lord, the DLSA. And it was appointed, my lord.
Rightly done.
But I was not given a single opportunity, my lord, to appoint my counsel.
Where from you get that you have expressed your desire to file and appoint a new advocate?
That is not there, my lord. I have not. Lord, how could there be a document, my lord? Because, my lord, we are the
You ought
accused,
to
my
have
lord,
filed
the
a petition.
custodial
You ought
trial
to
is
have
going
filed a
on.
petition.
My lord,
You are
the
in custody.
Yes, my lord. Custodial trial is going on, my lord.
So before custody through DLSA, you can say paralegal volunteers are there.
My lord, it's my lord.
Mr.
My
I
lord,
come
the
from the
constitute-
ground level, sir. I come from the ground level. I know how to do a work.
My lord, it's my constitutional right, my lord. Your lordship is much more acquainted with this.
So you are before a constitutional authority, sir.
As well as, my lord, statutory right, my lord, to appoint the council, my lord, according to my choice.
Have you expressed your desire even through a PLV
My lord, by way of
or by the Secretary DLSA, Alipurduar, intimating him that I do not want to take assistance of the lawyers of your choice. I want to appoint a lawyer of my choice. Have you written a letter?
No, my lord. Nothing has been done to that effect, my lord. What I have done, my lord, I have filed an application under section 311 for recalling of the witnesses.
At the
And,
time
my
of
lord, if it
the
is-
time of hearing, your appointed lawyer was not
my
represented.
lord, and if it could have been, my lord, considered, my lord, my defense, my lord, would have been done. My lord, I presume so.
So what can we do? If the court will wait for a considerable, how long the court will wait? Why your lawyer didn't appear? Take appropriate action against him.
My lord,
in the
lawyer
council.
appeared, my lord, with regard to, my lord, this application, my lord. Earlier, my lord, 311 application has been filed, my lord, which was kept in record, which was not heard, my lord. That is order dated, my lord, 17th of January.
Very good, but
2025.
the subject matter of challenge is 311, which has been rejected on 8/5/25.
Yes.
Learned PP in charge files Hajira. However, despite repeated order, learned defense advocate Satyajit Pal is found absent.
My lord,
I'm-
my lord,
You
kindly-
serve a copy upon Mr. Satyajit Pal. I will take up this matter in the principal bench. I will ask him to present here. And if I find that he is not diligent, I will refer the matter to the bar council. You give notice to Mr. Pal. PW 11 is concluded. Where is your application under section 311? Have you annexed?
Lord, page 33.
A good ground. Not at all a good ground, rightly rejected. On the day of cross-examination of the PWs, you were represented by the learned advocate who has been appointed from the DLSA Alipurduar. Am I correct, sir? You permitted to continue the cross-examination. You never made any correspondence, even with the Secretary DLSA, indicating your intention that you intend to appoint your own lawyer. For the sake of argument, even if I accept your contention that the learned trial court is in a hurry, you made no endeavor. On the day of conclusion of the cross-examination of the PWs, one application under section 311 was filed that you want to recross-examine those PWs by your own lawyer. And when that application was taken up, your lawyer, the lawyer of your choice rather, Mr. Satyajit Pal is found absent. Ashun, reject kori. I will not allow to press. I will reject it by a recent order. So what is the infirmity?
But we see the application as filed by the opposite party under section 143A of NI.
Page number, sir?
Page number, roughly it has been annexed with the original certified copy after the informed order. Maybe it is the last page. Just see the contention of that application. Rashid, there is no whisper of the awareness made by the opposite party of this application that what is the justification for granting that grant. There is no reasonable ground for considering the prayer under section 143A. There should be the reasonable cause, reasonable ground, only filing of the case under section 138 of NI Act that doesn't give the liberty to get the prayer, to get the order from the court of interim compensation. That is the itself definition says that. Lordship, moreover, that the series of documents I have not been given any opportunity to produce before the court at the time of hearing. Mere the hearing has been conducted by the court in his own speech, the order. Lordship, first page, 1, 2, 3, 4.
No, you participated in the hearing.
Participated in the hearing, but I have not given any opportunity to file the written objection with my documents. As because the series of
Have you filed any application? Seeking leave to file an application?
This case, starting this application came up before the court.
Huh.
And the court directed me to hear the matter. Please see, 1, 2, 3. Learned advocate for the accused persons strongly objected to such petition by state in this case.
Sir, has it been the disposed of on the very same day?
Same day.
No, sir.
Lordship,
See the first line.
18/3/2000.
Today is fixed for passing order.
Yes, Lord.
So where are those previous orders? That it was taken up for on the day of filing.
In the meantime, that the complainant didn't take any step to the court of law. That's why the case has been fixed for show.
Sir, your recall will not serve my purpose. I want to you said that on the very day of filing the.
I found that series of dates which has been deferred due to the complaint. So I am coming only on the merit of the application.
Absolutely justified, sir.
Lordship, I am referring all judgment only on the ground that what is the grounds that considered the complainant of the case submitted that impound check such and such number from UBI Alipurduar main branch amounting to rupees 5 lakh. The impound check has the arrest signature of the accused person on it. The said check was dishonored due to insufficient fund, after which due notice was sent to the accused person who did not pay such check amount with the statutory time period. The accused in the case has denied the legal liability to pay the impound check only. So only the ground has been taken by the trial court that the check has been issued and the signature bears in the check.
Place section.
Lordship, I'm
I look to the judgment, first place the law.
Lordship. Yes, Lordship. With your permission. Power to direct interim compensation, notwithstanding anything contained in the Code of Criminal Procedure such and such, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant in a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint. In any other case, upon framing of charge, the interim compensation under subsection 1 shall not exceed 20% or the amount of the check. The interim compensation shall be paid within 16 days from the date of such and such order, or within 60 exceeding 30 days, as may be direct the court sufficient cause. Sufficient cause being shown by the drawer of the check. Sufficient cause. On that point, Lordship, I am respectfully referring a judgment of Supreme Court just recent.
The interim compensation shall be paid within 60 days from the date of the date of the order and subsequent or within such further period not exceeding 30 days, as may be directed by this court on sufficient cause. That's what that is with regard to the time, not with regard to the compensation.
If the drawer of the check is acquitted to such and such, Lordship, if the findings please see the judgment
To
of
deposit the money.
Lordship, only on the basis of the sign as appeared in the check, that doesn't create the right to get the compensation, interim
sir,
compensation from the court.
What is the scope to determine that at this stage of disposing an application under 143A?
Lordship, only the check has been relied by the complainant in the court below.
Naturally.
I have relied the several documents to show and satisfy the court before going into the trial or scrutiny of that document. The check has been taken by the complainant by some other way. Please see this judgment, Lordship, please.
So, দাও কি বলছো দেখি।
Please come into the page number 49, Lordship, 49, para 22. When the court deals with an application under section 143A of the NI Act, the court will have to prima facie evaluate the merits of the case made out by the complainant and the merit of the defense pleaded by the accused in the reply to the application under section 143A. The presumption under section 139 of NI Act by itself is no ground to direct the payment of interim compensation.
Yes. The reason is that
And because presumption is rewarded. Even also in the complaint itself, my reply letter has not been annexed, in which it is specifically transferred that the check has been stolen by someone, thereafter the check has been misused by the different way. And the specific case has been started by Siliguri police station.
sir, give me a second.
Sure. Moreover, Doctor, this provision is not mandatory, this is the directive provision. My defenses will also be considered.
Take down. CD is available, Mr. Chakravarti? Charge sheet was submitted under which section?
353 and 356. Corresponding 137 and
Case of kidnapping. বাড়িতে রাগারাগি করে মামার বাড়ি চলে গিয়েছিলাম।
So 164 is very much clear. After 207 compliance of 207, we have to go. The actual person has been served with the free copy from the 164. I have added the 164 page number 17, my lord. The lordship will kindly tell us.
Where is the charge sheet, sir?
Last. This page number 23, 24, 25. And extra P4.
Page number?
23, man. 23, 24, and 25.
Where is the FIR written complaint, sir?
That is in page 60. The next page is the 160%.
Ashud, these are application under section 520 or 8 of BNSS. Stop. Continuation by filing the instant application. The petitioners prayed for washing off charge sheet number 202 of 2024 dated 30/05/2024 You enjoy.
maybe my lord will not, that part of.
My lord goes, my lord comes. So how the matter differs?
Another one thing more, before appearing any court, whether I am the advocate or anybody, I am appearing for anybody to my, on behalf of my advocate or as a friend, I will definitely peruse from the very first title to the last epidemic, so the one spelling and the date, and I beg apology and very much sorry, man.
Yes, well.
Unconditional.
You return to Roma today?
So if the case is, it's come day after tomorrow, then I.
It is in the month of November.
Let's see.
Very good.
Stay.
Have a safe journey. Yes, call the next matter.
Popular not to serve lots, but if you go to the problem. The most of the copies almost in this time.
Let the matter. বৃষ্টি হচ্ছে ম্যাডাম? Let the matter be listed before the next available circuit bench under the same heading.
OP2. লাইন কিছু তো এফিডেভিটের অপোজিশন হয় না তো
Lordship, I am on behalf of the opposite party too.
What is the informant?
Lordship, I want to file affidavit in opposition in against the petition which has been filed by the accused person.
You are the informant.
I am the informant, Lordship.
Who has died, sir?
Lordship, my son,
Your son.
my son has died.
Very good, very good. The parties to the instant revisional application are represented by their respective.
My lord, it should be some for the petition. My lord, asking this.
Please, my lords, I appear, my lords, for the private parties. Please, my lords, I beg to appear for the private parties. Can I request my friend to use the mic so that I can hear?
My lord, that is affidavit of service.
Yes.
And in this case, my lord, I have challenged the order dated 23/7/2025. It is annexed at the last page.
And this order was passed on the basis of the application which was filed by the IO, praying for collection of specimen signature from the accused person. And that order was allowed. And it is just a one-line order, my lord, passed in a mechanical way. And against that order, I have approached this learned, your lordship. My lord, I'll be relying on the judgment of the Kerala High Court.
CD is required to be looked into, no?
My lord, they are not, they are purposely not sending the IO is purposely not sending the CD because we have challenged the faulty investigation of the IO, and that application is pending before the ACGM. Before disposing of this.
What is the nature of the case which has been commenced before the trial court?
My lord, the forgery and forgery.
Milords, this is today, Milords, at an investigation stage only, Milords. Charge sheet has not been filed, the final charge sheet.
For further investigation stage. The charge sheet was filed. They filed an application for further investigation, which was allowed, my lord. There was a direction to file a final report, my lord. On that day, police did not file the final report. 2 applications was filed by the police, praying for further investigation, and another application for cancellation. Those 2 applications was pending, my lord. We filed a written objection, my lord. In that written objection, we clearly stated that there was a faulty investigation on the part of the IO, as because he has sealed the document which doesn't have any validity. And that application is
The
sealed.
affidavit of service has filed today on behalf of the petition is taken on record. The parties to the instant revision app.
Milords may hear me, Milords, before passing the order, Milords. I have some submissions to make. Lordship, am I audible?
But learned advocate for the state submits that CD is not available.
Milords, the only difficulty is this, Milords. I bow down, Milords. Your Lordship has granted them a stay on the first day, Milords, without hearing me. Milords, that stay, Milords, perhaps will continue in case the matter doesn't go. So your Lordship should at least clarify that other pending applications before the magistrate should be decided in the meantime.
I was prayed in this application also, a prayer has been made to dispose of my application, my lord, which is pending before the lower court.
CD is required to be looked into. Ki likhlam? Full stop. In considered view of this court, now CD is not available. Learned advocate for the state submits that CD is not available. Stop there. In considered view of this court, for effective adjudication of the instant revision application, the CD is required to be looked into. Stop. In view of such, let the matter be listed in the available circuit bench of November 2025 under the heading adjourn motion. Learned advocate for the the interim order of stay as passed earlier is further extended till the last day of December 2025 or till further order, whichever is earlier. Any other matter?
No matter, on the same matter, on that item number 14. As there are, we have found that there are certain mistakes in the dates and the number. So if you subject to the approval of your lordship, this lordship may kindly allow me to correct the thing, then I can correct. Otherwise,
Not-
the actual copy will serve upon my senior friend for the other side. So if this honorable court may kind enough to allow me, only just certain, that is a which you talk to have been 31st or which have made us 30.
Rear portion you cannot change.
No, I
What
will
is
not
your
say
item
only the-
number?
only the dates. I
Hey,
said
item
40,
number
40.
देखिए, একবার দেখি তো, what is your item number?
14, my lord.
দেখি ফাইলটা দেখি।
হ্যাঁ হ্যাঁ রেকর্ড আছে, আমি চেক পাই। হ্যাঁ হ্যাঁ আমি কারেকশন করে আমি ইনিশিয়াল করে দিই। In the list of dates, there are two dates has been misplaced, that is 14 and 16, which ought to have been 4 and 6.
Which one?
In the list of dates in the second page of the application. The third date, that
Page number.
page number, list of dates on the next, from the first is the second page.
That I cannot allow you to
List of
change.
dates.
I can allow on the first page, the page number 1, that is on the cost type.
Dates.
No, that cannot be changed.
And
একটা line একটা add করে
in
দেবেন
the
তো।
cost title, there is 31, that is 31, that is 30, can be made as.
That can be done only.
That can be done.
Only that can be done.
That I will do.
But not the prayer portion.
Not the paper, and list of the dates, my lord, kindly list of. The
No,
dates.
sir. List of dates.
A list of dates, my lord.
Is there any discrepancy?
My lord? Yes,
Is-
yes, yes. 16 should be 6 and the 21 is to be 2 only.
16:4 would be
6, 4.
then
And the upper, earlier one, the 21st would be only 2. 2nd April.
and third one,
And third one is the cost title, my lord, is that is the
date of charge sheet.
date of church.
31.
আচ্ছা ওইটাই জাস্ট একটা লিখে নাও প্রথমে লিভ ইজ গ্রান্টেড টু দি লার্নেড অ্যাডভোকেট অন রেকর্ড টু মেক নেসেসারি কারেকশনস ইন 2 places in the list of dates and in the cost title of the instant application regarding the date of charge sheet in court today. কল্যাণ বাবু এদিকে আসুন। উকিল বাবু এই দুটো ডেট চেঞ্জ করবেন, এই যে লিস্ট অফ ডেটস যে আন্ডারলাইন করেছি, আর এখানে চার্জশিটের এখানে ডেটটা কোথায় 31 ফাইন হবে, এটা উনি ডেটটা ঠিক করবেন। কিছু কমতে দেবেন না। এটা 31 হবে। Only 3 corrections. You want to
BNS, only the BNS in the prayer, I want to delete it. If this not, one department don't allow me, then I will not. The prayer portion, I will kindly appreciate.
prayer portion cannot be touched.
The BNS is only, the success of the BNS.
কি লিখলাম ওটা? So last line টা পড়ো।
Leave is granted to the learned advocate on record to make necessary corrections in 2 places in the list of dates and in the post title of the instant application regarding the state of charge sheet in Urdu.
Regarding date of charge sheet and regarding the relevant 2 sections of BNSS.
Lordship, deeply of the lordship.
তাহলে উনি এইটাও চেঞ্জ করবেন, এই জায়গাটাও চেঞ্জ কাটবেন। You will delete, I believe. You will delete, I believe.
I will delete it, I will cut it down with the signature of the advocate record on the.
After correction আমাকে একবার দেখাবেন। Then don't please remain it.
I am here.
Call the next matter.
Your Lordship, I am appearing in item number 18 on behalf of petitioner. I am audible, Your Lordship.
Yes.
I am for the
Your
state.
Your Lordship, I am appearing on behalf of petitioner in item number 18. My lords, the main arguing counsel, Mr. Nitin Banwala, is not well and he is down with because of dengue. Your Lordship, kindly grant us a short adjournment.
On behalf of the petitioner, an accommodation has been paid for. Prayer for accommodation is considered allowed. Let the matter be listed in the next available circuit bench under the same heading.
Briefly obliged, Your Lordship.
CD be retained.
Obliged, Your Lordship.
Yes. Next.
Lordship, appearing on behalf of the petitioner, please advocates on record. Was not here.
I
Not-
put the
not
defect of
visible.
complaint, Lordship.
19.
Right.
Same order. Next circuit. Under the same heading, huh?
The order হচ্ছে তো।
You are in 20 also? Who is appearing? Mr. Chakraborty, in High Court Circuit Bench at Jalpaiguri, the lawyers from the legal aid is available.
Yes.
That is Calcutta High Court Legal Services Committee.
No, madam.
Then
There is a separate circuit bench committee is there, madam. And advocate is also
no, what is the name of that committee?
ওটার নামটা কি জানো তো? কালকাটা একটা সার্কিট বেঞ্চ লিগ্যাল এড কমিটি না?
No, I want to know the name of the committee.
অনুরোধ কোথায় থাকতো? ও তো প্যানেলে আছে। হাইকোর্ট লিগ্যাল সার্ভিস কমিটি।
সার্কিট বেঞ্চের
High Court?
হাইকোর্ট লিগ্যাল সার্ভিসেস কমিটি সার্কিট বেঞ্চের জলপাইগুড়ি।
Ashwin. On perusal of the report, এই ওটা একবার দেখিনি, বলবো ওরা দেখি একবার দেখিনি। Sir, you have to make an endorsement. You are practicing for a cause. Corrected as per leave of this court, wherever you have made it. This is not the trial court, sir. This is the high court. এটা লেখান, আপনারা কি করছেন? Corrected as per leave, LEAV, don't write LIV. I will not allow. I have appointed MS Chakraborty. You retire. You have been discharged. Call the next matter. Hey, actually, in view of the actual line at court, in view of the appointment of MS Chakraborty, in view of the appointment of MS Chakraborty as learned advocate for the revisionist, the Fokalatnama has been executed in favor of, ওই নামটা দেখে নেবেন, learned advocate such and such is hereby cancelled. Don't make mockery with the court. Otherwise, I shall impose cost upon him. Call the next matter.
21 though. 21 minute, I am appearing for the statement. Maybe someone on last occasion, Mr. Counsel was appearing through virtual mode. Madam. দেখুন তো আছে কিনা কুনাল গাঙ্গুলি, কুনাল গাঙ্গুলি আছে এইখানে, আগের দিন ভার্চুয়ালি অ্যাপিয়ার করেছে, একদিন দুদিন অ্যাপিয়ার করেছে।
The whole difficult.
Yes, yes, yes.
This petition was filed on 13th August 2024.
Last two occasions they appeared. পাঁচশোবার একবার চেষ্টা করবি, পাঁচশোবার দেখে একবার
ফোন করতো এই নাম্বারটা,
শর্ট পাঁচশোবার তাহলে পাইলট বসে থাকে
এই নাম্বারটা ফোন
ইয়েস
না, কুনাল গাঙ্গুলি এখানকার না, প্রিন্সিপাল বেঞ্চ।
আরে ওর এখানকার অ্যাড্রেস আছে তো,
অ্যাড্রেস দিয়েছে কুনাল গাঙ্গুলি।
22 arm for the state. Simple matter. Well, it's simple matter. They have asked for transfer of the case from Siliguri, from Jalpaiguri to Siliguri. It's an NI Act case. What happened in this case, my lord, after the
The last occasion, I have served the copy through the post, it was returned, without proper, it was returned, it was not copy, now copy has not been served. I was directed to copy served through the landed advocate to Jalpaiguri. The conducting advocate of this case, I have given the copy of the petition along with the annexure to the advocate, conducting advocate of the law court. He has informed me, the conducting advocate of the opposite side is not receiving the copy. She is saying that, that he is not interested in this matter. That's why I could not serve the copy.
my lord, actually the
Return in sub, I don't have this copy. I had matter of court number 1. I could not prepare to. Can you make it not?
no, thing is that this is not cases. Thing is that the matter is already pending before the jurisdictional court. What happened in this case, my lord? No, he is for the petitioner. He is for the petitioner. In the case, check was issued in his favor, and after that was dishonored, he filed a case. And when the documents was exhibited, it was found that both the banks are of Siliguri. So, Siliguri, within the jurisdiction of Siliguri court, the court of Jalpaiguri has no jurisdiction. And thereafter, the accused persons, they file an application for dismissal on the ground of jurisdiction, and it is pending. In the meantime, he has come with an application for transfer of the case. Is it maintainable?
From Jalpaiguri to Siliguri.
That is their ground why this case should not be on that ground of jurisdiction. And now he has come with fair hands. He has come before the higher court.
I have a. I am equipped with the judgment of the Supreme Court, where it was said that if I have the opportunity should be.
No. When it is pending, my lord.
They're not 24.
Learned advocate for file it. The petitioner is not represented.
The matter be fixed tomorrow, might not then for here.
Some of his close family members suddenly who actually got the present on the last next week.
It's a very simple matter, madam. It's a civil in nature dispute given a criminal charge. A land dispute, madam.
Washing.
Quashing of FIR and the procedure.
On behalf of the opposite party number 2, a request
I filed my lord. But then subsequently I come to know against whom I filed the contempt, my lord. That person has changed. Another person, Kunshuk Chondo, has come in his place, my lord. At the time when I filed, he was that person, my lord. But now subsequently he has changed, my lord. So I am required to amend the application, my lord, and I am required to change the name of that contempt, my lord. That's the problem, my lord. I know, my lord, because if I don't change, my lord will take that.
he is no more the contender.
The person has changed, my lord. There's someone else in his position now.
No, no, the alleged contemner who has been added in the cause title, he will remain.
Now, in this case, whom should
Transfer will absolve him from the contempt.
that that is what. Because the person who is in his place now is supposed to comply with the order.
And the previous person?
He has gone, madam. He's been posted somewhere else, madam. So he is no more the person who is going to comply with the order.
But when the order was served, he was
He is
there. Then what will happen with him?
Now, person, position, my lord.
I understand your contention.
Would you like? What person can say? Then I have to add him also.
Liberty is given to the learned advocate for the petitioner. Liberty is given to the learned advocate for the petitioner to add the new
I'm grateful.
One time, Murali Dhoro, this is at 10:28. The matter was this is not evolved. We Well, we are meant for one second appeal, but that appeal has been filed in my matter along with section 5 application. The section 5 application is heard by your lordship, my lord. And then he also directed to sub the copy of the application to be listed. It was no single because unless section 5 is allowed, that cannot be admitted. That cannot be listed for admission hearing. Now, yes, only single bench. Jalpaiguri circuit bench. That matter appeared before just the first day. Thereafter, one of the if you only section 5 application, if the restored that appeal is that the section 5 is allowed, that will be automatically that will be that we can get a chance for admission bench. Will it possible? I shall go back then. I can go. Today not possible. But I can supply the number also. My law is directed to sub copy. We sub the copy. Yes, under the yes. Yes. But I supply the number. Hand over the slip.
My 50, I'm for the petitioner, my lord. My lord, although I have challenged 2 orders here, but no, to be very candid, my lord, the application in connection with that order has not been annexed, my lord. I've sought for sought for leave, but the certified copy I have not yet received, my lord. Otherwise, I'm ready with the matter. If my lord wants to hear it, I can proceed. Certified copy of the application. Order is here of the application. No, no. At that time, it was not available. So I've sought for leave, my lord. So if your lordship wants to hear of the matter, I can proceed, my lord. And this is at the motion stage, my lord. New motion. No. I've sought for leave, my lord, in my petition, my lords. My lord, I've applied for the certified copy. I have not yet received it. My lord. My lord, my lord. Application under order 9, rule 7. Under order 9, rule 7 of the Civil Code Procedure Code. My lord. CPC. Grateful, lordship.
I can fix the another. Not to join.
My lord, I am the petitioner of these cases. My lord, it is an petition for speed disposal of the cases which is pending before the Mecklenburg Court Junior Division till 2016. This is the affidavit service, my lord. Dada. Yes, my lord. I am the plaintiff. My lord, this is a land acquisition case. Okay. In the year 2016, the Eastern Railway, without any notification, without payment, any compensation, grabbed the property of the petitioner, which is who is plaintiff are the landowner of the places, but they buried a pole into the land. Suit for title suit, my lord. When the railway buried a pillar into the land of the petitioner, they went to the Mecklenburg Court. My lord, I'm coming in this position. My lord, I'm coming. Actually, what happened? They filed title suit in the Mecklenburg Court in the year 2016. Petitioner, plaintiff. Please come to page number 3. Para 2, my lord. After appearance, defendant filed an application under Order 7, Rule 11D, read with Section 151 for rejection of claim. Reason for non-issuance of notice under Section 80 of CPC on the ground that notice under Section 80 of CPC is a mandatory provision for issuance of notice against Union of India or the state government prior to filing any suit against it. In reply, my lord, please come page number 43. They moved to the district court, and what the district judge Kuch Bihar passed an order regarding this. Page number 43, my lord. From considered portion. It appears from the case record that the plaintiff had filed this suit after taking leave from the learned court under Section 82 of Civil Procedure Code. No. Order 7 rule 11 rejected by district judge for in favor of against defendant. Okay. District judge. They moved to district judge for rejection of plaint of the petitioner. And in respect, district judge reject the petitioner Order 7 Rule 11D with 151 is not made liable to be rejected against defendant. Defendant went to the district judge court to reject the petition of the plaintiff, which they filed without serving 80 CPC notice. Yes, my lord. Order is there under the above fact and circumstance, I deserve my option that the instant petition under Order 7, Rule 11G, Civil Judge, Junior Division, Mecklenburg.
You are saying this year
They appear also district judge. I'm coming. My point. It's a civil judge, Junior Division. After that, my lord, please come page number 5. Para 5, my lord. Para 5, my lord. When the civil judge rejected the plaint, then what the petition on 16/4/2024, the court fixed the date for hearing of urgency of filing. Later, on 16/4/2024, no hearing had been concluded. Hearing also done. Hearing also done. At what stage, my lord, is lying on order passing. First, they did up 19/5/2025, my lord, already hearing have done. Fixed date for 27/6. No, my lord.
urgency hearing. The what the defendant want, the plaint should be rejected because there is no section 80 CPC notice.
I understand.
Yeah, rejected. Again, on the same footing, the decision is pending with the learned court. Yes. Yes. Trial court made a date for hearing. When the hearing had been concluded, urgency hearing, my lord, urgency hearing. The what the urgency for that they filed the petition under section 80 without section 80 CPC. My lord, kindly come to page number 5.5, my lord. Next date is fixed for 1/8/2025. The date is fixed for order. Before also, that also I don't know what the order for. The order is for whether the petition should be rejected or the petition should be entertained. But the order is still not passing by this learned trial court, my lord. Yes, my lord. I place one judgment also, my lord. Please come page number 7.
What is the urgency? I don't know. I no idea.
My lord, I'm trying to give you submission that petitioner, the defender of these cases want to reject the plaint as the plaintiff did not meet 80 CPC notice, my lord, before filing this title suit. And against them, they went to a civil judge, junior division, they rejected the petitioner. Order 7 Rule 11. After that, hearing has been done. The what the urgency for? What the urgency for that the petitioner did not file? Why the petitioner did not? Yes, my lord. Why? Urgency hearing also done, my lord. Is that yes?
Why is your copy of the urgency?
Urgency with a copy. My lord, it's already been completed by the parties, my lord. Now the date is fixed for order only. And the learned trial was not passing the order. And that's why I'm saying. Yes, my lord. Several date has been done, but not passing the order. My submission before lordship, direct the trial court to pass the order and conclude the hearing as soon as possible. My lord, that injunction hearing. The injunction hearing, my lord, with the petitioner filed. In High Court, my lord. My lord, come to page number 20, then you can understand. My lord, please come page number 20, my lord, please, then you can understand what the petition is for actually. My lord, come to page 20, my lord. They filed this suit petition, my lord. The petitioner want injunction against the defendant, and that injunction is still not heard by the learned trial court from 2016. Yes, my lord, still pending. And my submission before your lordship to conclude that this short hearing so the petitioner get justice for learned is pending from 2016, my lord, in the court of Mecklenburg. This hearing had not been done yet.
Order number 20 does not reflect so.
Don't make any order regarding these cases till now. There is no order passed regarding these cases.
The individual charges that I have on behalf of the
No, criminal search.
Lordship, I must pass over, Lordship. Lordship, short pass over, Lordship. Conductive counsel is, Lordship, kindly, Lordship. Lordship, short pass over, Lordship. Lordship, humble request, Lordship, kindly.
Lordship, in this matter, Lordship, I'm paying for not today, Lordship. Conductive counsel is addressing before court number 4, Lordship. নাম দিতে হবে কি?
For the petition. And in a suit for declaration and permanent injunction, petitioner before lordships are the plaintiff, my lord, plaintiffs. My lord, the court below was pleased to pass an order of injunction restraining the defendants from carrying on any changing the nature and character of the suit property, my lord. My lord, since despite they were being made aware of the injunction order as well as despite appearing in the suit, my lord, they have carried on such construction, my lord. I approached the police station to preserve the order. Police could not help me because of since there was no direction for the court below. So I have approached the court below under section 151 for seeking police help, my lord. That was hard in part, but the same has not yet been disposed of, my lord. My lord, 25th August is the next date. On several occasions, the matter has been adjourned, my lord. If the matter may be disposed of on this next date, my lord, I'm seeking that on, my lord.
Data part.
Invention
Let the matter be listed before the next available circumstance. Not today করে রাখুন তাহলে। Not today করবো। ওটা কেটে দিন।
My lord, kindly, this matter may be pass over, my lord.
Which one?
57.
Password is not possible.
Madam, Mr. Amlesh Roy, senior counsel, is in court number 2. He is for the petitioner, my lord.
Password. ये तो पास ओवर 57 पास ओवर 58 call 58 What is going on, sir? Where is Mr. Mishra? Pass over then.
The lordship service is not affected, my lordship.
ফাইলটা দেখি এটা তো ডিপার্টমেন্টে ক্যানটাকে শো করলো না ডিপার্টমেন্টে নামানো নাকি এটা ক্যান ওয়ান কিচ্ছু আসেনি কিচ্ছু আসেনি No report is submitted by the department. সেটা না দিলে কি করে বুঝবো আমি পুরো নিচে রেখে দিয়েছেন এই ফাইলটা দাও The compliance report as filed by the deputy registrar
It is also sub but not affected.
it is submitted on behalf of the petitioner. Their service is not yet complete. In view of such, let the matter be listed before the next available circuit bench under the same heading.
I'm appealing to the petitioner also.
কি ফাইল করছেন উনি?
Rashid, this is section 24 application of the alimony pending like.
Give me a second. Give me a second.
Rashid,
Give me a second, sir. Is 61 or 62? 61.
pay 20,000 rupees per month from the date of filing of the application.
Which order is it? It is an application under 227.
Rashid,
Which order is under challenge?
Rashid, the order dated,
9/5.
yes, Rashid, 9/5/2024.
In an application under section 24 of the Hindu Marriage Act.
Rashid.
You are aggrieved with what? Quantum.
Yes, Rashid, quantum, and it is from the date of filing the
Give
application.
me a second.
Rashid, my contention is.
Give me a second, sir. So what is the infirmity?
Lordship, the petitioner's per month income is 30,875 rupees, page 33. And I have filed the supplementary affidavit, Lordship, annexing the affidavit of asset filed by the wife in the.
Page number, page number.
Page number 33, annexure T4.
Give me a second.
Net payment 30,875.
Also, the petitioner is a grade 1 officer.
Wait, you will get your chance, sir. Page number 33 is your pay slip.
Yes.
Huh.
Net payment.
What does it indicate?
Net payment 30,875.
What is your gross earning? 70,000 and odd. Professional income tax, professional tax, contributory social scheme, benevolent fund, maintenance deduction,
Net payment in hand is 30,800.
FCI Employee Credit Society. You have taken loan. FCI Employee Cooperative Credit Society means it is for what purpose is the deduction is made?
Lordship, it is maybe some kind of a cooperative society in the.
Where from will get your net earning?
Net earning 30,875, just below the gross earning. Net payment.
No, what is this FCI employee cooperative credit? Have you taken in loan?
No, Lordship, it is not a loan, Lordship, it is a society.
No, why this amount has been deducted? That I intend to know.
Maybe some kind of cooperative loan. Lordship.
Why you have taken loan?
Lordship, then I have to take instruction. Lordship, you kindly see the earning of the wife.
Where from will get that?
Lordship, I have filed a supplementary affidavit annexing the affidavit of asset.
It has been filed today.
No, earlier. Was affirmed on 12th February 2020.
কোন supplementary affidavit কোথায় পাবো?
It is in the record. Your Lordship, give me, I can find it for you.
Supplementary affidavit, yes. Page number?
Start from page number 3, Lordship. Page number 3, monthly income 14,000. And the wife, she is holding 3 vehicles. All these 3 vehicles are commercial in nature, and they are running the vehicle for the school cab purpose.
14,000 per month towards what purpose?
That is, they have submitted, Lordship, monthly income.
He has movable assets.
Yes, sir. Movable, immovable. Both.
School fee 22,000 per month. Your children's school fee is 22,000 per month. Huh?
Lordship, kindly see page 7, annual turnover.
Wait. You please come to page number 5. Your school fees is 22,000 per month. Grace daycare, after school care 2,000 per month. Very good. Book stationery 12,000 per year. Understand. Private tuition 2,000 per month. How old is she? 6 years. Achha, pocket money 500 per month. A girl of 6 years gets pocket money of rupees 500 per month. My goodness.
Lordship, I have studied in a school where 3 months fees were 12 rupees for tiffin only. 12 rupees fees for 3 months. Lordship, kindly, Lordship, execution proceeding is going. Lordship, kindly give a limited stay, Lordship, kindly. Your Lordship has seen the affidavit of asset, Lordship. Is this believable? Kindly, Lordship, kindly. Execution proceeding is going on.
Lordship, kindly. So your lordship has seen the affidavit, as lordship. Is this believable? Kindly, lordship.
How much you are paying? You are not paying nothing.
Lordship, how can he pay 20,000 rupees, lordship?
From the year of 2000.
Right.
So past the year of 2023.
No, 24.
Application was filed in the year.
Yes, that is.
And the order was there to pay from the date of the filing.
Yes.
But we did not, a single person has been given. Moreover, the 3 vehicles that they are claiming, there is not a single vehicle there present behind it.
Considering the accuracy of the petition is husband. Considering the accuracy of the petition is husband. Will there be a stay of the operation of the order number 95 to 24? And followed by the additional instruction to go to Jalpaiguri. On partition. The petition is husband. The phone paying rupees 3,000 for one. The opposite party wife hasn't by way of interim maintenance.
Lordship.
Month by month. Effect from January 2025. And interim maintenance shall be paid by the 7th day of the taxing month. Till disposal of the institution.
Lordship, one in the just.
The entire areas of pay. In terms of this order. Shall also be paid. In 2 installments.
Lordship, kindly read with 3, lordship.
2 installments. By the last day of October 2025. Failing which the interim order of stay as filed by the court will automatically stand in.
Deeply open.
Yes, maybe. Now the dependent is the petition. Yes or not?
Yes, two.
6-2. Dependent, petitioner. Yes. Just suit for. Yes. But dependent, just suit for. Okay, I can custard with that. The suit for declaration and recovery cost for sir. In the suit, the plaintiff has set out the valuation of the property 1 lakh. 12 lakh rupees. Then if also can you see my written statement. Written statement, my lord, page 16. Page 16. The suit of 2014. Written statement 2015. I filed that the dependent filed the written statement 2015. Then you will also come paragraph 8, next page, page 17. In the year 2000 on 21st April 2015. April 2015. 2015. Then will also come next page, page 17, paragraph 8. Paragraph 8. The suit has not been properly valued. That admittedly the plaintiff is not in possession of the suit land, and hence the plaintiff should have paid for recovery costs of the suit on payment to advertisement court fees on present market value of the suit land, which is not less than 25 lakhs. This, until the suit is properly valued and until proper court fee on present such market value is paid by the plaintiff, the suit cannot proceed. Yes, 25 lakhs. Yes. Yes. So cross five. 7-6 note 7-4 B. That is not the issue here. That is not the issue. Page 20, paragraph 20, my written statement. The allegation made in paragraph 30 of the plain are not admitted to court, as already stated, suit has not been properly valued and thereby proper court fees has not been paid. So much so when there is a prayer for disclosure title and prayer for recovery consideration, the suit must be valued and the market value of the property question and the valuation court fee has to be paid under the law. Then, my lord, thereafter, evidence was started, issue framed, trial commenced, page 22. That was within the knowledge of the plaintiff. Can I mark it? In the year 2015, that's what I raised the point. Then, my lord, examination of that examination in chief, such and such, PW1. Come, state where your losses come. Page 23, last line. Last was full line. I have filed this suit with regard to measuring 4 cutter, 10 cutter, 10 cutters, 10 chottaks. I cannot say what is the market price of the suit land at the time of filing the suit. I cannot say the present market value of the suit land. Next, cross examination. Next page. I cannot say whether the market value of suit land was around 20 to 25 lakhs at the time of the filing suit. I cannot say whether the suit land, the mortgage such and such differed. Then next page, page 25. That further cross examination, then further cross examination, then page 26, concluded discharged. That is 22. Gone over the evidence closed. Now page 27. Then March 2024, I think, yes, 12 March 2024. He filed an application. When the argument says the filed an application for amendment, kindly see the amendment. The humble petition under order 6 rule 17, read with section 151, the court filed with the plaintiff for amendment to the plain in respect to the above noted suit on the grounds stated therein, herein below, most explicit. The plaintiff filed the above suit against the defendant before the learned court, praying for declaration or title, recorded consideration or permanent injunction, and to this date fixed for further argument. That the valuation of suit mentioned in the cost data in paragraph 30 of the plain, the suit is required to be changed from rupees 1 lakh to such and such, 20 lakhs, 33 such and such by amendment. What is the due diligence? Now I am putting question to myself. That was within his right when I filed the written in the year 2015. Evidence was started, everything completed with the press for argument. He filed an application along with that. But due diligence, and there must be some abatement to the delay. But I can show 2 judgments of the Honorable of Supreme Court. Now, learned trial judge has allowed this application. I have come to this application. That order, impugn order. Yes. I have filed a written objection. Yes. Sorry. Page 30. My written objection. Written objection. The case, paragraph 2, the case was fixed on 4th March 2024 for argument. And the argument on behalf of the defendant has been commenced. Completed what is specifically argued that the suit wrongly valued and should be rupees 25 lakh. That has been specifically raised, mentioned in paragraph 8 of the written statement, as well as in paragraph 20 of this is stated, where there is prior for declares or title with prior for recovery position of the suit must be valued at the market value of the property in question, and on such valuation court fees has to be paid under the law. At the time of argument, the alleged deed of purchase marked as Exhibit 5 has been shown to the court, where it is shown the certificate of market value assessed registering authority rupees 20,36,466 on the date of the said particular deed dated 27/8/2010, whereas the suit has been filed in 2014. Thus, the valuation sought to be put by amendment is not correct, should be 25 lakhs. Next, the suit is now at the stage of argument after taking evidence of both the parties, but in the petition, no reason has been assigned by this one has been made in spite of the point raised by the defendant in their written statement. Filed on 1st April 2015, as well as during cross-examination of the plaintiff number 1 on 6 June 2022. Thus, yes, sir. On 30th April, my lord. Today, this date is fixed for passing order in respect of the petition filed by the plaintiff on 12th March 2024 under such and such. This court has heard the learned advocate for the parties at length on the aforesaid petition on 1st April 2024. The record is taken up for passing necessary order in respect of the petition. Plaintiff seeks amendment of the plan with regard to valuation of the suit. The defendant in his written objection has registered his objection of the ground that the proposed valuation is erroneous, and the plaintiff seeks amendment at much belated stage without assigning any reason for the delay. So, as to the veracity of the subject matter of the amendment, the court noticed that while considering the petition under Rule 17, such aspect cannot be considered. Such as cannot be considered. No, proviso, my lord. With regard to the ground of delay, the court finds that indeed the plaintiff has filed the petition praying for suitable amended at belated stage, but the fact remains the present requirement of proposed amendment with regard to valuation suit was admittedly hinted by the defendant. It's admission. In the written statement, it is settled principle law that court should be liberal approach while considering the prayer for amendment of the plain injection of the amendment might have the maintained to the suit on pure technical ground. The amendment sought is not of such nature which is barred by law of settled principle of law regarding amendment of pleading. For the interest of justice, a prayer amendment should be allowed. Such and such, everything hardship caused to education due to negligence act of printing cost such and such, the prayer amendment is allowed subject to payment of 1,000. Then what I am saying, recent Supreme Court judgment. Recent Supreme Court judgment. That can be allowed. Yes, my lord. 2019, Volume 4 Supreme Court cases. Paragraph 6. Well, first, paragraph 5. Leave to amend may be refused if it is interested totally different now, such and such, such and such, such and such. Unless the court comes to a conclusion that in spite of due diligence, the party could not have raised the matter before commencement of the trial. Therefore, the burden is on the person who seeks. Paragraph 5. First, paragraph 5. Leave to amend may be refused if it introduces totally different new inconsistent case or changes the fundamental character suit. The proviso orders 6 Rule 17 CPC virtually prevents an application for amendment of pleading for being allowed after the trial has commenced. Unless the court comes to a conclusion that in spite of due diligence, the party could not have raised the matter before commencement of the trial. Here the trial has been commenced. The proviso to the extent curtails absolute discretion to allow amendment at anything. Therefore, the burden is on the person who seeks an amendment after commencement of the trial to show that in spite of due diligence, such amendment could not have been sought earlier. What's the amendment, my lord? I am putting question to myself. Then paragraph 6, your lordship, anything. As mentioned, supra, suit was filed in the year 1993. And at the point of time, defendant number 2, 4 to 6 were not made party to the suit. The plaintiff 1 to 5 and defendant number 1 to 3 were the only parties. They filed a joint memorandum of dismissal of the suit on such and such, which was within 1 or 2 months of filing the suit. The compliance petition came to be dismissed by the court such and such. In compliance petition, it was noted that a joint family property was divided by Miss Sunbound in the 1972. If the partition had already taken place in the year 1972 and was acted upon as per the Panchayat Parikha, then plaintiff number 1 to 5 would not have filed the suit for partition and separate possession in the 1992. Be that as it may, it is clear from record the suit was being prolonged on the pretext or other by the plaintiff 1 to 5. And ultimately, the application for amendment of the plaint came to file on 1st September 2008. By that time, evidence of both the parties had been recorded and the matter was listed for final hearing before the trial court. If there indeed was a partition of joint family property earlier, yes, sir. Maybe hot said, but ratio is a then gynecologist paragraph 6. 6 very important. I read 1 6 first paragraph, then next page. Next page. Plaintiff wanted from making the necessary application for amendment to the plaint earlier. So also nothing prevented them from making this necessary amendment in the plaint itself. In as much as the suit was filed in the year 1993. Even according to plaintiff 1 to 5, they came to know about the compliance such as 1993 itself. There is no explanation as to why they did not file application for amendment till the year 2008. Even given in the suit had been filed in the 1993. Though even when the plaintiff number 1 to 8 came to know about the partition deed such and such, they kept quiet without filing application for amendment the plaint within a reasonable time. He had also kept quiet 2015. Evidence of both the parties has been allowed, completed. When the matter was placed finally, what is the averment? That is mandatory, my lord. On the contrary, the proceeded to cross-examine the PW1 thoroughly and took more than 5 years time to get the case of PW2 completed, and only thereafter an application for amendment filed. That too, when the suit was posted for final hearing. Then having regard, next page, regard to the totality of facts, we are of the considered opinion, the application for amendment of the plaint is not only belated, but also not bona fide if allowed, would change the nature of such and such, that application was but according to but there's a due diligence must is the only 2 lines averment. What's the averment? That one another judgment order 2024 volume 3 Supreme Court case. Paragraph 8. Only 2 paragraphs. So allowed tomorrow, the examination was both the parties were completed. 8. Proviso to order 6 rule 17 CPG provides that no application for amendment. Last year's page 5. No application order proviso to order 6 rule 17 CPC provides that no application for amendment shall be allowed after trial has commenced. unless the court comes to conclusion that in spite of due diligence, but my submission before is a due diligence requirement. The party could not have raised the matter before commencement of a trial. In the case in hand, this is not even pleaded case of respondent 1-2 before the trial in application for amendment. The due diligence was that here at the time of filing the suit in not seeking relief paid for and such and that, all that was pleaded was oversight. Since same cannot accept as ground to allow amendment in the pleading at the fag end of the trial, especially when admitted is the facts were within the knowledge of respondent 1 and 2. That application amendment was disallowed. The real paragraph 8. The my submission before that in the year 2015 is specifically pleaded in the written statement. That was his kept quiet. It was within the knowledge. The exams of both the parties are completed. When the place for hearing, he come out with an application. That is mandatory, my lord. Otherwise, my lord, after amendment, that provides us with that the Supreme Court has specifically stated. It's a recent judgment. Rule, that I have not filed, but anyway, my lord. But the one fixed for hearing? Yes, sir. Everybody will come, yes.
Very technical. New fact for information. This is a valuation. Actually, declaration of patent was fought for on the basis of 150. That was statement value was 1 lakh and government value was 2 lakh, 20 lakh something. And accordingly, at the preliminary stage, it was valued at rupees 1 lakh. And they never challenged the value directly by filing any application under valuation act. Yes, they have stated.
Probably which is why the trial court has claimed like issue and whether the suit is properly valued or not.
Yes, my lord. Actually, regarding the suit valuation, valuation of the suit, and the court has ample jurisdiction to ask for to file the court fee and valuation to be increased at any time. As per section 11 of the Court Fees Act and section court can do anything. And 114 of Civil Procedural Code, 114 of Civil Procedural Code. The court fee. No. Well, you provide the whole or any part of any fee prescribed for any document by the law for the time being in court relating to court fees has not been paid. The court may, in its discretion at any stage, allow the person buying such fees payable to pay the whole or part as the case may be.
Supplementary is there, supplementary report this code is there. There is a learned code is actually justified to allow your application for admission. If you want to do it, thing among the provide of orders in use there.
Yes.
There is the sole confidence.
Yes. Actually, Lordship, by allowing this amendment, that defendant shall not be presented anyhow. New fact was incorporated. And accordingly, court fee was requisite court fee was filed. And at the cost of 1,000, they have accepted the cost. Subsequently, they filed this application, challenging that order. I am referring one judgment, old judgment, 1957 Supreme Court.
No, at that time the provision was not there.
No, not that time. No, that have ended.
Actually, no.
At that time, that was not, that provision was not there. Yes. Either way. না, আমি তো বলে যাবো যা জানেন তো আর ভালো হবে। হ্যাঁ?
That's why it cannot be. On behalf of the opposition party. The matter will be the next and we will have under the same.
Lordship,
a petition.
Lordship, I beg to appear virtually, my lord, by praying for my lord's leave to appear virtually for respondent number 1 and 2, my lord.
Lordship, on the prayer of made by the petitioner, senior counsel Onimesh Mishra is not well. That's why 1 day accommodation needed. Obliged.
Grateful, my lord.
On 65 on the last occasion, my lords had directed them to, my lords, serve us a copy through either email or WhatsApp, my lords. And they served us a copy, my lords. It's not legible, my lords. It cannot be printed out and it cannot be understood, my lords. If they would be directed to, my lords, serve a legible copy. No, my lords. There was a direction, my lords.
লর্ডশিপ আমি পিটিশনার নাম্বার 2 এর মা বলছি। লর্ডশিপ আমি পিটিশনার নাম্বার 2 এর মা বলছি। আজকে পিটিশনার নাম্বার 2 আলিপুর থেকে জলপাইগুড়ি সার্কিট বেঞ্চে রওনা দেওয়ার পথে হঠাৎ করে খুব অসুস্থ হয়ে পড়ে, তাই ওকে নিয়ে একটু ব্যস্ত আছি লর্ডশিপ। তাই নেক্সট সার্কিট যাচ্ছি ম্যাডাম। লর্ডশিপ শুনতে পাচ্ছি না।
ও আই এম সরি, এবার শোনা যাচ্ছে?
না, হ্যাঁ এখন শোনা যাচ্ছে, বলুন।
আচ্ছা, ওই আপনারা যে উনাকে কপিটা পাঠিয়েছেন না, সফট কপিটা হোয়াটসঅ্যাপে না থ্রু ইমেলে,
WhatsApp
সেটা খুব লেজিবল নয়, অর্থাৎ ওটা পড়া যাচ্ছে না। আপনার ওনাকে একটা হার্ড কপি মানে প্রিন্ট আউট দিন ওনাদের।
আচ্ছা লর্ডশিপ আমি বলে দেবো।
What's your name?
It's Mayank Bhandari.
You are led by Mr. Ghosh.
Mr. Ghosh.
Learned advocate appearing on behalf of the respondent number 2 and 3 submits before this court that the soft copy of the instant revisional application as supplied to him is not legible. In view of such, the petitioners are directed to serve a hard copy of the instant application together with all annexes to the learned advocate for the respondent number 2 and 3, preferably within 7 working days from today. Stop. The petitioner number, আপনি কে?
আমি পিটিশনার 1 এর ওয়াইফ আর পিটিশনার 2 এর মা।
Oh, on behalf of the petitioners, what's your good name? আপনার নাম কি?
পাপিয়া বণিক, পাপিয়া বণিক।
Lordship, this is the totally violation of advocate, Lordship. They are not appearing in person, Lordship. They should be appearing in person, Lordship.
আপনাদের কিন্তু কোর্টে আসতে হবে, আপনাদেরকে তো আমি চিনতে পারবো না, আপনি কে, আপনি ক্লেম করছেন আমি বুঝতে তো পারছি না, আপনাকে চিনি না, আপনার কোনো আইডেন্টিটি প্রুফ আমি দেখতে পাচ্ছি না।
লর্ডশিপ, নেক্সট সার্কিট আপনি করে দেন, আমি ওরা নেক্সট সার্কিটে চলে যাবে। আজকে আমার মেয়ের শরীর খুব অসুস্থ, আর
ঠিক
আজকে
আছে, কিন্তু উইথ পার্সোনালি আসতে হবে কোর্টে উইথ আইডেন্টিটি প্রুফ, নাহলে বুঝবো কি করে?
আচ্ছা লর্ডশিপ।
কি লিখলাম?
আর লর্ডশিপ, ওনাদেরকে হার্ড কপি দেওয়া হয়ে গেছে লর্ডশিপ।
আরেকবার দিন, আরেকবার দিন, নেই বলছে, পেয়েছেন?
Lordship, and for the state, Lordship.
সব দেওয়া হয়ে গেছে, সব ওর কাছে
Private respondent did not
No, no, please supply another copy. আরেকটা কপি দিন। The petitioners are represented today by the wife of the petitioner number 1 and the mother of the petitioner number 2, Papia Boni, in virtual mode. See, press for an accommodation. Let the matter be listed before the next available circuit bench. Under the same heading, the petitioners are directed to appear before this court in person along with their identity proofs at the time of hearing.
Grateful, sir.
Call the password matter. $57 and $58 password.
57 tomorrow because I'm covered by your lordship, judgment 62. And then after the judgment, but just you also give us the judgment, that will help me. Can you take it tomorrow? Can you upload the judgment? I just take this one.
On West Bengal Court Fees Act.
No, this is what is the amendment of plain my lord, commencement of trial. This ratio has been led by your lordship that perhaps it may help me. Whether this is, I heard your lordship. Can you see, but I sometimes I get it today.
I'll try.
Can you take it tomorrow?
Item number?
57.
57 and not today karo.
This is the way over sometimes they take sense. Okay.
For the wife of this party, the husband was a matrimonial suite and in the same husband by a under order 6
Where is he? Where is he? The petitioner is not represented. Let the matter be listed tomorrow under the same heading. Very good. Let the matter be listed before the next available circuit bench under the same heading. MS Senanovis, learned advocate appearing on behalf of the opposite parties, he has been requested to communicate the server copy of this order to Mr. Mishra, learned advocate appearing on behalf of the petitioner, and to file a receipted copy of such notice on the next day of listing. সিভিল ডিভিশন ম্যাটার আছে নাকি আর সব শেষ করে ফেললাম?